Good evening, everyone. I'm Lara Bomzer. I'm one of the attorneys at Sapega, Daly, Pope, and Perri, and I am glad that you all are here tonight joining me at Don't Lose Your House, Protecting Assets from the Cost of Long-Term Care. This is a really important topic. I spend a lot of time with my families talking about this very topic. Sometimes they're coming to me thinking about how to protect assets in advance of a long-term care crisis. Sometimes they're thinking about how I can help them in the midst of a long-term care crisis. But it's a fair amount of how I spend my day is helping families who are struggling with this very subject. Just a few housekeeping rules before we get started. You are all muted during this class, but you'll see that on the side there is an icon for chat. And that means that at any time, please feel free to enter a question into the chat box, and I will stop from time to time and I will answer some of those questions. So here we go. Let's talk about, can I really lose my house? The answer is sort of, right? If you wind up entering a nursing home and you spend all your money on your care, you may need to then sell that house, right? And use the sale proceeds of that house to help pay for care until the state is willing to come in and start paying for your care. And we'll talk about Medicaid, and we'll talk about the different factors that go into Medicaid eligibility. But this is kind of the short answer, right? The purpose of this class is to talk about the long answer. And so how can this happen? How could it be that I would spend all of my assets and even have to sell my home, right? And use that money to pay for my care. And part of that is because Connecticut has some of the highest long-term care costs in the country. The average monthly cost of care in a nursing home can be $15,000 a month, which is, as you can see, about $180,000 a year. That's a lot of money. And for many of us, right, that can easily wipe us out within, a few years at best. Medicaid is that program that will step in and pay for care when you have spent down or run through your assets. And again, that's the fail-safe, is the Medicaid program. But there are many factors that go into that program, which is, again, what we're going to talk about during this class. So again, what is Medicaid? Medicaid is the state and federally funded program that will pay for long-term care here in Connecticut. We are fortunate in that we have both a benefit for nursing home care as well as home care. And that's part of the benefit, right, of being able to age in place and being able to be at home and live in the dignity that you want and you deserve and not losing your house, right, is that Medicaid will be able to pay for your care at home. But they want you to have little to no funds. They want you to have basically exhausted your money before they will step in and pay. Medicaid financial eligibility, right? There are a few different rules and factors that go into the eligibility for someone for Medicaid benefits. One are your assets. A person applying for Medicaid benefits, whether at home or in a nursing home, can only have $1,600 in assets in his or her name. Not a lot of money, right? This is a program that was meant to help people who were impoverished, and Medicaid is saying, even if you had assets, you need to spend down and be at the asset level that we will accept you in order to pay for care. They also look at your income. When they look at your income, if you go into a long-term care facility, into a nursing home, they will say that essentially, minus some small deductions, your money, your income will go to the nursing home, right? Consider it like a copay. If you're at home, the state says, we know you need to buy food, you need to put oil in the oil tank. We want to make sure that you have money to do that. And so they will allow you essentially to keep your income if you stay at home. That said, there are some caps. There are some income levels that the state says you can meet but not go over. So if you have more than about $2,700 worth of income, the state says, we'll let you keep everything above that, but you're going to have to get involved with a nonprofit organization called Plan of Connecticut. And what happens is essentially Plan takes that overage income, they receive it every month from you as the applicant, and then you submit bills to them, and Plan will take that extra money and pay the bills. So for instance, let's say you had $3,000 in income. You're $300 a month over that income cap. And we're looking at fixed income. We're looking at Social Security, pension, things of that nature. Every month, $300 of your income would go to Plan. And you'd also submit bills. You might say, I have an oil bill due. I might have a food bill. I might have some extra expense that I paid for. And you would submit those bills to Plan. Plan then pays those bills from that $300 a month that you've given them. It's an administrative step that the state requires in order for you to be able to receive care at home. So without having Plan involved, if you have more than $2,700 or so in income every month, the state will just blatantly deny your ability to access the Medicaid home care benefit. So again, when it comes to income, nursing home, it goes to the nursing home, your income, but if you're at home, you're basically able to keep your income. And we'll talk a little bit in spousal situations, some of the nuances to that, what that means for the spouse who's living at home. The final big factor in the financial eligibility rules for Medicaid is a transfer of asset rule. And what that means is Medicaid essentially is a very big financial audit of all the transactions that you've done on any and all bank accounts, financial accounts, investment accounts, retirement accounts over the last 5 years. They want to know where every withdrawal went, where every deposit came from. They think you have an offshore account in the Cayman Islands with millions of dollars. They're not doing this out of the goodness of their heart, right? This costs the state a lot of money to pay for people's care. And they want to make sure that you absolutely are eligible for this benefit. And what the state essentially says is that if you give away or have given away during that 5-year look back more than $14,500 per person per year, right? That's what they look at. Then you are ineligible for benefits for 1 month. So if I've given away during that 5-year look back $29,000, the state says you are not eligible for Medicaid benefits for 2 months. The problem in part is that the state says that that penalty, that transfer of asset penalty, starts to run when you have $1,600, when the state has made a determination on your assets, right, has made a determination on your application. And as a result, people can find themselves in a big pickle because now they don't have the money to pay for their care, whether they're at home or whether they're in a nursing home. And now they're stuck because they've given away assets that the state says you should have kept because you knew that perhaps you would need long-term care, and instead you gave your money away. So how do I get on Medicaid, right? How do I make sure, you know, gosh, if I'm worried about a long-term care crisis, I better just give my house away, I better give my money away, and I better just go right on Medicaid, right? Isn't that the best way to do it? And again, not a great idea, right? We have to be very careful because of this 5-year look back period, because the state will say, you're giving away all your money, you're giving away all of your assets. Well, guess what? We're going to penalize you because you didn't use that money and those assets for yourself. So here's our first scenario we're going to look at, right? And George was a single person, and all of these scenarios, just so you know, are truly based on families that I've worked with, clients that I've helped. And in this case, George had fallen and he broke his hip, right? He's a single person. He had $150,000 in assets and he had his house. And he entered a nursing home so he could rehab his hip. And as often, sometimes what happens, even under the best of scenarios, a person goes into a nursing home expecting to come home, and sometimes they can't. And basically, this was George. And the cost of the nursing home was $15,000 per month. And so by month 10, he had spent down. He only had $1,600 in assets in his name, but he still had this house, right? And so before going on Medicaid, he might and most likely will have to sell his house in order to pay for more care, right? Because the state's not going to let him own this house and wind up being in a nursing home and say, okay, we'll pay for your care here, George, when he has this asset that he can sell and turn into liquid. But does George have to sell his house in order to get on Medicaid right away? Not necessarily. And so what happens is when I work with someone like George, who starts spending down his assets, who runs out of money, we can still apply for Medicaid benefits. He has $1,600 in assets in his name, and he's got this house off to the side. During the application process, the house is not always considered what we call an available asset, because the application process is one in which George has to put the house up for sale, but the state can't force a buyer. The state can't say, George, you have to take the first offer that comes along. George has to wait until he has an offer for fair market value that he is willing to accept. So can he take this house and say, gosh, I've got to get rid of it. I'm going to sell it to my nephew for $20. No, because the state would take the position that essentially George has made a gift to his nephew, right? He's not selling it for fair market value. So if the house is worth $300,000 and he sells it to his nephew for $1,000, he's made a $299,000 gift. That's the position the state would take. And in taking that position, he's now kind of put himself again in that pickle we talked about, because he's created a transfer of asset penalty during this 5-year look back that will negatively affect his eligibility for Medicaid. So what happens? We put the house up for sale. It's considered an inaccessible asset because, again, the state can't force a sale. They can't force a buyer to come out of nowhere. But once the house sells, George could potentially lose his benefits. So if he doesn't sell the house before the benefits come into place, once he sells the house and the money comes into his name, he may very well lose his benefits. He may need to spend down that money, or sometimes we have high-level strategies we can use to protect some of the money he received from the house sale using a single premium immediate annuity, something we'll talk about later a little bit, a way to be able to make sure that we are protecting assets and turning them into income streams. And as a result, George can still receive Medicaid even though the house is up for sale. The question's going to be, what happens when this house sells? What, if anything, will we be able to do at that time? Or will George be forced to spend down all of the money he received from the sale proceeds? And then once he is at $1,600 again, that is when he would be able to be eligible to apply again for benefits. So a little tricky, a little bit of a nuance there, but we were still able to get George on benefits even though he had a house in his name. But again, what about home care, right? We want to save the house. We want to protect the house. We want to try to make sure that we can live and age in the house. And so what Medicaid says is, yes, nursing home care and applying for benefits in nursing home care is very different. We know you don't need to live in your house, so we want you to sell it. But when you are applying for Medicaid home care benefits, and there's a crisis and you own your home, the state says, we can't ask you to sell the house. You need a place to live. We know you want to live in that house. So you can be at $1,600 and apply for Medicaid benefits for home care and own your home. And the state will not say that you are not eligible for benefits, provided, of course, that you meet all the other eligibility requirements. However, once you pass away, the state can put a lien against the property because they're allowed to recover from the house when it sells, right? The state says, okay, we'll let you keep your house, but one day when you're no longer with us, we're going to put a lien on that property, and when it sells, we're going to get paid back for all the benefits we've paid out on your behalf. And of course, similarly to what happened with George, if you start out with home care benefits and you're receiving them through Medicaid, but then you wind up in a nursing home, same situation. The state's going to say, okay, you don't live in that house anymore. We're going to expect you to sell the house and then use those sale proceeds to privately pay for care before we, the state, will step in again to pay. Now we're going to talk a little bit about a married couple, right? This is Jane and Bob. Again, real families that have come to see me, and it's very often what happens is one spouse needs care, right? And so we talked a lot about what the eligibility rules are if you're the applicant, but this we're going to talk a little bit more about what happens to that spouse who's in the community, right? What happens to that person at home who's planning on remaining in the community? And in this case, Bob had a bike accident, he broke his hip, Jane was fine, and they have $150,000 in assets plus a house. Jane is healthy, wants to stay home. Obviously, she'd like Bob to stay home as well. And so the Medicaid rules allow Jane to keep the house and some of the money. And we'll talk about, again, what that looks like. And Bob can then apply for Medicaid right away. So what happens is when you have a married couple and you're applying for Medicaid benefits, the state looks at the two of them as a team. They basically combine your assets, they look at everything together, and they say, okay, we know that Bob can only have $1,600 in assets, but what about Jane? What is she allowed? And Jane is allowed to have essentially half of all her assets with a maximum value of about $148,000 and a minimum of about $50,000. So what does that mean? That means if Jane has $500,000 in assets, plus a house and a car, which she's allowed to keep, she can keep $148,000. And we'll talk in a second about, well, what happens to all the other money above the $148,000, right, that got Jane to $500,000. If Jane had $100,000, and in this scenario she had $150,000, she only gets to keep half of that maximum. So she gets to keep $75,000. The bigger issue, of course, becomes what happens when you have much more than that cap of $148,000? How do you protect, how do you keep all of the other money above that amount? And that's where this law firm went to federal court a number of years ago and argued that a spouse in the community should be allowed to take all those assets above the $148,000 and convert them to an income stream. Because as you can see, a wife in the community or a spouse in the community is entitled to keep as much income as she receives. There's no cap. So unlike Bob, who at home would need to have a cap of about $2,700, right? Jane can have as much income as she wants. And so we successfully argued that we could use a special income stream annuity called a single premium immediate annuity. Not an annuity you run out and get tomorrow with a financial advisor. It's only used in crisis planning for Medicaid eligibility purposes. It's a Medicaid compliant annuity. And essentially what it does is it converts all of those assets to an income stream. And so as a result, it allowed Jane to be able to protect the money that she received that was above the $148,000 because she receives it over an actuarially sound amount of time, and she gets the same amount every month. Now, the big caveat to this strategy is that the state of Connecticut said if we're going to let you do it, then we're also going to expect to be the primary beneficiary on the annuity. And whoever you want as a contingent, your kids, other family members, that's up to you. The reason for this is because the state says that if Jane, during the term of her annuity, which is usually, I would say, about 5 years is what you shoot for, if she predeceases Bob, then the state says, well, we're going to get paid back from the balance of that annuity all the money that we've paid out so far on behalf of Bob and ongoing until Bob passes. And if there's anything left, then it will go to your contingent, your backup beneficiaries, your kids, let's say. So the goal, of course, is for Jane to be healthy, to live her life, to be at home, to receive all of the annuity payments over that 5-year term, and essentially beat the state. She gets all of her money back. But if she doesn't set up that kind of annuity, the state's going to say, go out and buy a fancy house, go out and buy a fancy car, find some way to be able to spend down that money, because we're not going to give Bob any kind of Medicaid benefits without it. I'm going to stop for a second. I have some questions. So one of the questions is, what happens to Social Security benefits? And as I said before, Social Security is an income stream. It's your income. So it's part of what is considered income for Medicaid eligibility purposes. We have a question about, is the spouse, let's say the spouse in the community, what about her 403B or her pension? Are those considered to be assets? A pension is considered an income stream, but a 403B is considered an asset. And that's where, again, it's part of my job is to manipulate the assets. So it could be that in Bob and Jane's scenario, most of the assets were in Bob's name. Most of the assets needed to be moved over to Jane in order for Bob to only have $1,600 in his name. And even though we talked before about, well, you can't move assets out of someone's name because it's considered a gift, and then you're going to have a transfer of asset penalty, not so with spouses. Spouses can move assets between each other without any penalty at all. So part of my job when I meet with families like Bob and Jane are often to be able to manipulate the assets and let them know how best to transfer assets to the spouse in the community in order to get first the eligibility for the spouse who needs the care. And then we talk about, okay, how are we going to keep that $148,000 or whatever half of that cap is of their assets? And then are we going to need to annuitize anything? What else are we going to be able to do with the assets? So this person is asking if a person is on Medicaid and then able to buy a house, when the person passes away, does the money from the sale go to the state or the beneficiary if the person dies? So what I'm saying is that if you have a home and you own it and you go on Medicaid, the state has the right under the law to put a lien against that property and be able to get some of those sale proceeds. Now that is if you are the owner and the applicant. If you're a spouse in the community and you own the home, the state cannot lien it. As long as you, the spouse, continue to live there and use it as your primary residence, the state cannot lien that property. If you have a joint savings and checking account with adult children, is that money safe? The state says if the Social Security number is yours, if essentially your adult children are on that account for convenience, right, to be able to help you or have access to money if needed, that account is yours. That account is the parents'. They do not view it as, okay, you own it jointly with another child, so only 50% of that account is yours. They will look at it as being 100% yours. Okay, I'm going to move on and we'll answer some more questions. So as I said, when we have spouses, one of the benefits is that transfers are not penalized by Medicaid, unlike if we were to give our assets away to children, right, or grandchildren, or whoever we give them to, right? That's when the state says for every $14,524 that you give away, you're going to be ineligible for 1 month before we, the state, will step in. Not so when you manipulate assets between spouses. We also have a couple of other situations where the transfers are considered exempt. So if you have a disabled child, right, a child who's been deemed disabled, whether it's on SSI, whether it's a child who's on SSD, often we have ways of giving assets to that child and there is no transfer of asset penalty. Sometimes we even have someone who meets the exemption of what's called a caregiver child. A caregiver child is a child who perhaps lives with you and essentially takes care of you, right? And but for your care, that child's care, you would have been in a nursing home without that person being there. And the state says if you can show through medical evidence, through documentation that that's what this child is doing for you for at least 2 years prior to applying for Medicaid benefits, then there are ways of compensating that child, of giving assets to that child as a thank you, if you will, for taking care of you during this difficult time. And so it's a very strong standard that you have to meet. And it's something that, again, when I work with my families, we really have to get the doctor involved. We have to get a lot of evidence involved to be able to show that this child meets what is called the live-in caregiver child exemption. So another exempt way of transferring assets to a child without the state penalizing you. So I'm going to look at some more questions because they're coming in fast. If a retirement such as a 403B has beneficiaries, are those still part of assets that Medicaid can take? Yes. Essentially, the state says any asset you have is on the table. And it's not, again, that Medicaid can take the assets. It's that the state expects you to spend down your money before they are going to step in and pay for your care, right? The state says you have a 403B, or you have bank accounts, or you have investments, or you have, mutual funds. And the state says, why should we pay for your care? You have money, you should pay for your care. Again, when we have spouses and we have ways to manipulate assets, we often will find ways to do that to protect as much as possible for that spouse in the community. But sometimes if someone has a very large 403B or 401k or IRA, some kind of retirement asset, and they're applying for Medicaid benefits, it becomes very complicated because the only way to get that money out of that person's name is to liquidate that account. And if that account, again, is very high, there's an income tax consequence to liquidating that entire account at one time. And that's another factor and another wrinkle that we talk about when we meet and we try to figure out exactly what would work for you given the assets that you have and what are the downsides, what are the liabilities, what are the things you need to know before we make final decisions. So I'm just looking. How does long-term care insurance factor in? Is it safe to say that if you have insurance, there is no need for Medicaid? Long-term care insurance is obviously a product you can buy in which it often has what's called the daily benefit, right? There's a certain amount that this insurance policy will pay out per day to cover your cost of care. Whether it is enough, it's hard to say, right? It depends on your policy. It depends on if you have an inflationary rider, right? Is your policy daily benefit going up with the cost of living? Does it have a COLA, right? Is it going up every year? There's a lot of different pieces to long-term care insurance. And when I meet with families, we talk about, is it worth it to continue? Will it cover the cost of care? Is it something that makes sense? For people who are interested in purchasing it, what are the premiums going to be? Obviously, as you age or you have an underlying risk, it's harder to become insured. So long-term care insurance does play into it, but it doesn't mean you won't need to have the state come in and pay for care at some point. All right, I'm going to move on for a sec. We talked about the spend down, right? Sometimes when I meet with my families, we don't need to do an annuity right away because we have items to spend down on. So it could be that you have home improvements, dental work, prepaying your funeral, right? Not fun, but a necessary evil. You may say it is time to upgrade my car, so I do want to purchase a new car. These are all part of the Medicaid spend down. As long as you're spending it down for yourself or your spouse, it's fine. If you said, well, you know what, I'm going to go take the entire family on a cruise and spend $30,000 doing it, the state would say, no, you've just made a gift to all those people and you're going to have a transfer of asset penalty. So you have to be very careful about what you choose to spend down on and understand that it has to be for your benefit. Sometimes the spend down covers everything we need. and we're able to attain Medicaid eligibility for the spouse and the community and the applicant. Sometimes when we have people who have a certain amount of wealth and there's a big spend down, right, that would be needed. Sometimes we're doing a little bit of a spend down, and then we're looking to that single premium immediate annuity, that SPIA, right? We're looking to the SPIA to be able to annuitize the rest, because again, we don't want to have you frivolously spend down money on things that you don't need just for the purpose of attaining Medicaid eligibility. What's really the best way to protect your house and your assets? It's to plan ahead, right? So when I meet with my families, often one of the big things that I hear a lot of is, I wish I had met with you 5 years ago. I wish I had met with you 10 years ago, right? Because it's all about planning. It's all about getting beyond the 5-year look back. And how do you get beyond the 5-year look back? Is that you try to do your planning when you're healthy, when you're well. And while nobody has a crystal ball for any of us, we don't know what tomorrow holds, if you are basically in good health and able to think about protecting assets in advance of a long-term care crisis and giving that a shot, you may put yourself in a better position long-term than others who come to me or any other elder law attorney in crisis saying, now what do? I didn't do anything. The best way to plan is by using a Medicaid irrevocable trust. And this is a really common strategy that, again, I use with my families when it comes to protecting assets. A trust is essentially a legal document that acts as an empty pot, and you fill it with assets. Now, not all assets are applicable assets for an asset protection trust. Usually it's real estate, sometimes bank accounts, investments. You're not putting life insurance in here. You're not putting retirement accounts in a trust, right? Those remain in your individual name. But essentially, you create this trust as the grantor, the creator. But you're appointing someone else to be your trustee. It could be a friend, it could be a family member, but the idea is that you are not the person who's going to be in control of the management of these assets. And then the trust also has beneficiaries. It talks about who has access to the trust assets during your lifetime. And it also reads a little bit like a last will and testament in that it says, when I am gone, here's where all these trust assets will go. Here are my beneficiaries. When we talk about how do I make sure I don't lose my house? How do I make sure that one of the most important pieces of my estate, right, stays intact, that it stays protected, and that I have the ability to age in place at home without worrying about selling my house or the state liening my house? Often putting it into this asset protection trust is the way to do it. And it's one of the most common types of assets that I advise be put into one of these asset protection trusts. This trust is irrevocable. Irrevocable means it can't be amended, it can't be revoked, it can't be changed. That said, there are some provisions that allow you some flexibility. And what it does is, by allowing you the flexibility to change your trustees, to change your beneficiaries, to sell your house during your lifetime if you'd like to, and have the trustee take the sale proceeds and maybe purchase a condo, or you want to downsize, it still allows you a lot of flexibility and indirect control over the assets. But from a day-to-day standpoint, or an investment management standpoint of assets, if you choose to put cash or investments in the trust, it's the trustee who's responsible for that. The benefit, of course, is that after you transfer these assets into this trust, and we do a bundle, we do a one-shot deal, right? We trigger 5 years, and then the hope is that you continue to live your life, do your thing, and after 5 years, these assets are fully protected. So what that means is, should you and your spouse, if you have one, need any kind of Medicaid, need care, the state can't say, go take all the money in that trust, go sell that house, go do everything that you can do with those assets to pay for your care before we'll step in and pay. Those assets are off the table. Those are the assets that you're leaving as a legacy for your children, for your family, for your charities, whoever it is that you may wish to leave assets to, knowing that the state cannot make a claim against them. Now, one of the most common questions I get, of course, especially when I teach a class like this, is, well, what happens if during the 5 years there's a crisis, right? What happens if someone in year 3 has some kind of stroke, winds up in a nursing home, or needs that care at home, right? Now what happens? And that's when we have to think about, well, what kind of care is needed? How much does that care cost? And is there enough money left to pay through the balance of the 5 years? Right? Is there enough money left to pay for 2 years of care? And if there isn't, or it would be a hardship to do so, we sometimes have to unwind the trust and work with crisis planning strategies, some of which we've already discussed, right? With annuities and spend downs, and do whatever we can to be able to try to protect whatever assets we have left. But unfortunately, we weren't able to get through the 5 years. So there is risk involved, as there is with everything, but if you don't try and you don't give it a shot, then you might have 5 years anyway that are free and clear and healthy, and you could have protected some assets along the way. So again, it's a very common tool that I use when I meet with my families. Okay, so I'm looking at, what if elderly parents are living with their children? Will the children's income come into play with Medicaid? So that answer is no, right? When they are looking at you, they are looking at your assets and your income. They are not looking at your children's income as a source of support, if you will. They are not looking at your children. Let's see. Can the state go after a family trust established by the person applying for Medicaid? Depends on the trust, right? And I'm going to talk in a minute about how some of you may have a revocable living trust, right? And I'm talking about an irrevocable living trust and what the trust differences are. So it depends on the trust terms. Yes, there are times that there are trusts that are available and would have to be used to pay for someone's care. Are assets and a home that are placed in a trust considered assets? And again, we'll talk about the differences between revocable and irrevocable trust, because yes, they are considered assets. It's just dependent on what type of trust you have put the assets in and whether they have asset protection or not. If you put your house into an irrevocable trust and then sell your home or downsize to a condo or an apartment, what happens? So generally, when we have a house that's in an irrevocable trust, you get a lease, right? You get a lease as the grantor, as the person who funded the house into this trust, to say, hey, I get to continue to pay all the carrying charges. But as I said before, you also have the flexibility to say to your trustee who you trust, who's responsible and acting in your best interest, we're ready to downsize. We want to go buy that condo over there. And so the trustee sells your present home. The condo has to be for the amount that's within whatever the sale proceeds are from the house, right? So it has to be something that the trust can purchase with whatever money is left. So if you have $300,000 now in a trust bank account, you can't go buy the $500,000 condo. You don't have enough money. So you have to be thoughtful about what condo you're going to purchase. But let's say that you found that condo and it's $250,000. Now the trustee is going to purchase the condo with $250,000 of the trust money. The condo's in the trust's name, so it's still fully protected. You're going to have another lease that will be prepared saying that you get to pay the carrying charges. And the trustee is also going to have a bank account in that trust with $50,000, right? That the trustee can then keep as a bank account, invest, do whatever he or she thinks is best with the money. But you are able to downsize if you choose to during your lifetime. So that is not necessarily an issue. So what happens if you don't use a trust, right? I have families who come to me and say, I'm just going to give my house to my kids. Why should I use this trust? The problem is when you give assets away, especially something like a house, and you give it to children, Now the child essentially owns it. And what if your child gets divorced or is in a bad accident and is sued? What if you have a falling out with your child? What if your child winds up developing some kind of addiction or problem or passes away unexpectedly? There's so many reasons how that house could be at risk, and you could lose that house even though the intention was, hey, I just need you to hold on to it for me and protect it for me so that I can get long-term care from Medicaid one day. The trust is a much better vehicle to be able to use when it comes to gifting for Medicaid asset protection purposes. The assets in the trust have creditor protection. Even if your kids are your beneficiaries of the trust, they don't own the trust assets, right? The trust owns the assets. And so even if they have a divorce or they're sued, they don't own these assets. They can't have these assets be taken from the trust because they're named a beneficiary. They haven't invested yet. They haven't gotten these assets. So for that reason alone, it's a much, much better choice when it comes to protecting assets, both for Medicaid and from worrying about beneficiaries, worrying about kids holding on to your assets and having some kind of financial problem in the future. And as I said before, you maintain some control. You can change your trustees. If you don't like your trustee, you can remove your trustee, you can change that person, and you get to clearly spell out how these assets will be distributed, right? Who you want everything to go to one day. By giving up the asset and control, the access rather, and control of the trust assets, that's what triggers the asset protection, right? The state says if you were the trustee, if you had access to all this money, well, then all this money is available to you and you need to spend it down on your care. And that's where we talk about revocable versus irrevocable, right? So many of you may have something called a revocable trust. You may have assets in your trust and you may believe that these assets are protected for Medicaid asset protection purposes, but they're not. You can't be trustee, you can't revoke it, you can't amend it, you can't change it. All of those different wrinkles mean that you have a revocable trust, not an irrevocable asset protection trust. So it's really important that you look, if you do have a trust, and look at your trust terms and see, am I the trustee? Am I allowed to revoke or change or amend this trust? Because if you are, or you are able to do so, then this is not an asset protection trust. So these are the two types of living trusts, right? Living meaning a trust that you create during your lifetime. Revocable trusts are most commonly used to avoid probate, right? To be able to take care of out-of-state real estate and property, to avoid probate out of state, right? You have a house that now is in Massachusetts and you also have it funded in your Connecticut revocable trust to make it easier for your beneficiaries one day. Trusts are private documents, right? So if you have a disagreeable family, if you have estrangements, if you have nosy neighbors, right? This is a private document. And it also can provide for disability planning, right? Who's going to take over for me as trustee if I can't do so? And sometimes there are flexible estate tax provisions and all sorts of other reasons that someone might have a revocable trust. The one thing a revocable trust does not do is protect assets from a long-term care crisis. That is only an irrevocable asset protection trust. That is the only type of trust that will do that. And again, the big key factors are that you are the creator of the trust, but you are not the trustee. You have no access, no control. You are not the beneficiary of the trust. Those are the big takeaways when we look at an irrevocable trust versus a revocable trust. So I have a lot of questions here. I'm going to try to get to some of them before we wrap up for the night. And so I'm going to go see what we've got here. So someone says, does Medicaid have a specific daily benefit, or how is the daily benefit determined? So a daily benefit is a benefit that's determined with long-term care insurance. When it comes to Medicaid, the nursing home, let's say, might have a daily rate, or the home care agency might have, an hourly wage that a home care attendant is paid, right? And then Medicaid has a negotiated rate that they pay in those situations. So they pay less than someone privately paying for that care. And that's why nursing homes in particular are also very happy when someone wants to come in and privately pay, because they get more money from a person who's privately paying versus someone who is receiving care through the state. That said, the care that someone receives, whether it's at home or in a nursing home, is the same. The workers don't know who's on Medicaid and who's not. The home care worker doesn't know who's on Medicaid and who's not. There's no difference in your care. Okay. Let's see. So if your child is the trustee of an irrevocable trust and you set a deal to have the child withdraw funds for your living expenses, can you do that? That's not really what the benefit of the irrevocable trust is for. They're not supposed to do that, right? You are not a beneficiary of this trust. The child, the trustee, cannot give money from this trust to you. So if you can't manage and pay your expenses and your needs based on the assets that you still have in your own name, then this is not the right strategy for you. So just to clarify, when I talk about funding an irrevocable trust, we don't fund all of the assets you have, right? Even if you had bank accounts and investments and you had a house, and we don't take all of it and move it into this trust, because we don't need you to say, gosh, I don't even have $20 to go to the movies anymore. Who am I going to ask to give me money, right? The goal is not to impoverish you. The goal is to thoughtfully think about the assets you have that are large, or perhaps assets you don't use very often or you don't derive an income stream from, which is again why a house is often one of the top assets we think about and talk about, and putting it into that trust. So you still have money in your name. You still have assets in your name. And the goal is that you need to spend your assets, not trust assets, and not ask your trustee for the trust assets. The next question is, if there is a crisis within the 5-year period, are you stuck without resources to pay for care? As I said before, we're not putting all of your assets into the trust. And so you still have assets that are in your name that are available to you to pay for care. And if something happens, a crisis unfolds during that 5-year look back, that's when we're looking and I'm working with you to see, do you have enough money in your own name still to pay for care for the remaining balance of the 5 years, or do we need to unfund this trust and unwind it and then work with some kind of crisis planning? How does a trust affect the trustee? For example, school loans. So the trustee is a fiduciary. A fiduciary is a person who is financially responsible for managing assets in this trust. The assets in the trust are not the trustees. The trustee doesn't own the assets. The assets in the trust are not part of the trustee's own estate, right? So while I can't speak 100% toward financial aid for college loans and things like that, a trustee, they don't own these assets. You own these assets. In fact, the trust has to have your social security number. It doesn't even have its own EIN or tax ID number. So it should not affect the trustee when it comes to personal loans and financial aid and things like that. Can you have 2 trustees? Yes, you can. We often have more than one trustee because sometimes people want to name more than one child or they have 2 children. And generally those trustees can act severally. Severally means they can act independently from one another, because sometimes you have a child who's out of town, the other one's in town. You don't want them joined at the hip every time someone needs to sign a check, right? Or if they have to make an investment decision. The idea would be that it gives them both the ability to manage the trust assets without the other's involvement. That said, if there are big decisions to be made, the goal would be that they're going to be talking to each other and making these decisions together, but at least one of them can call the broker. It doesn't have to be both of them at the same time. Okay. What if you own a house with someone other than a spouse? So I don't know if this relates to questions about the asset protection trust, but if you own 50% with a sibling, let's say, right, of a house, you can transfer your 50% interest to the asset protection trust, right? You can transfer your interest to the trust. So even if you own the property with someone who's not your spouse, we still have ways of being able to try to protect that asset. This person is asking if a single person has fewer options to protect assets, seemingly like the only option is the irrevocable trust. So a single person may not have the benefit of transferring assets to a spouse in a crisis. As I said before, sometimes in certain circumstances, we have some higher level strategies we can use with the SPIA in the right situations to be able to try to protect assets for a single person. Sometimes the single person has an exempt transferee, like I discussed, a disabled child or a live-in caregiver child, and there are other ways we can protect assets. But you are correct that the asset protection trust, the irrevocable trust, is often one of the most common vehicles that would really help a single person, because they do have, they do not have the option potentially of manipulating assets with a spouse if they're in crisis. The trust is not affected if you move to another state. So trusts are portable. What that means is generally each state will recognize and honor a trust that was created in another state. However, what I always say is that Medicaid is, again, a federal and state funded program for a reason. There are federal laws that all the states generally have to follow, like the 5-year look back, but the states also have their own laws, and they vary from state to state. And so what I generally advise my families is that if you do move out of state, the first thing you want to do is sit down with an elder law attorney in that state to make sure they're reviewing your documents and make sure and see, are there any tweaks? Are there any items that they need to talk to you about in relation to the trust, the asset protection trust that you created, to make sure that it is also upheld in your new state? Does a partner have the same benefit as a spouse? So the answer is no. When I say no, it means that unless you are married, you cannot transfer assets to your partner and give them the same status from a Medicaid eligibility standpoint as someone who is married. So they basically look at you as two single people. They never look at the partner. They don't look at the partner's assets. There's no need for the partner to manipulate assets. They just look at the applicant as if he or she was a single person. Can the state go after an insurance payout after you die, after being on Medicaid, when it's paid out to a beneficiary? So the state says that if an insurance policy has cash value, that it needs to be cashed out potentially, right? Especially if you're the applicant, if it has more than, you know, the $1,600 in value and it's going to keep you from getting on Medicaid. That said, if you have a group policy, if you have a term life insurance policy, right, some kind of policy that has no cash value, the state says that's okay, you can still keep that in your name, which means when your beneficiary is still on that, you know, policy and you pass away, ultimately that beneficiary is allowed to keep the money and the state is not allowed to come after it. We have, let's see, I think I hit just about everyone's question. We have 5 minutes left, but I think and I hope that you found this class to be beneficial. It's a lot of information. Medicaid is not for the faint of heart. It's a huge paper chase. And I think it's really important that you think thoughtfully about your assets. You worked hard for them, and you need to think about how you can protect them, how to make sure you have good, solid legal documents, powers of attorney, healthcare directives, wills, as well as, you know, is an asset protection trust right for me, right? Is it the right option for me? It's not always right for everybody, but it's something to be explored. And I hope that you have some good takeaways from this presentation, from this class. And I hope that you all have a great evening. Thanks so much for joining me tonight. Good night.